May it please the court, my name is Jacqueline Aleman, and alongside my co-counsel Daniel Sawyers, we represent the petitioner, Roxanne Torres, in today's case.
We will demonstrate that the officers in today's case violated the Fourth Amendment rights in regards to Torres because, one, a seizure did in fact occur under the original meaning of the Fourth Amendment, which has been established as this court's precedent, as represented in Hodari DV California, and with respect to the seizures of persons, the common law of arrest. And two, construing an unnecessary force claim to be dependent upon something as trivial as the successfulness of a seizure at the time the force is applied, bars any accountability of officers facing repercussions that would otherwise be prescribed had the suspect not been successful in fleeing.
When looking at whether or not a seizure took place, the 10th Circuit Court reflexively applied the definition of a seizure to be solely dependent on whether or not the suspect succeeded in avoiding capture. This, however, directly contradicts previous rulings and the definition of a seizure according to common law. The appropriate definition of seizure should focus on the state action rather than any actions or reactions of the person or person being seized, as the Fourth Amendment functions as a prohibition on particular state actions. The definition and use of the word detain and arrest at the time of common law that will be referred to are interchangeable. Looking at the history of the Fourth Amendment, we can look at California v. Hodari D, which claims at the time the Constitution was adopted, an arrest was the quintessential seizure of a person. Furthermore, according to Samuel L. Johnson's Dictionary of the English Language, which was published in 1785, the definition of an arrest included any seizure or taking of power. Under this understanding, all seizures are arrest, so the common law definition of arrest informs the definition of seizure. Both common law and contemporary holdings from courts have long established that a seizure does indeed take place when a use of force is present.
Looking at common law, in the case of Ginner v. Sparks, a bailiff was attempting to make an arrest, at the time interchangeable with a detention. However, the plaintiff evaded the attempt by fleeing to his house. The court held that no arrest was made at the time due to the fact that the bailiff never touched the plaintiff. The court stated that if the bailiff had touched the plaintiff, then that would construe an arrest. The only possible discrepancy in the application of this case is a difference in force used against the subject. In today's case, Torres was injured by a firearm, whereas the plaintiff in Sparks would have been subject to an arrest if the bailiff had touched them. The general reasoning in these two cases are mutual in the use of force, and the fact that the use of force, whether it be a gunshot wound or simply touching, was used in order to gain control of the suspect. Looking at the holding of contemporary law, this court should still come to the conclusion that a detaining took place, regardless of the fact that the petitioner was able to flee the scene.
In the case of California v. Hodari D, an officer attempted to make contact with the petitioner. However, the petitioner fled the scene at the time of initial contact and was later fully apprehended after they threw away evidence. The petitioner in this case moved for the evidence to be suppressed. However, this court in its ruling determined that since there was no actual seizure at the time the evidence was thrown, the Fourth Amendment claim was invalid. The court in Hodari D used common law to apply a test in which, in order for a seizure to be present, there must either be the application of physical force, however slight, or where that is absent, submission to an officer's show of authority to restrain the subject's liberty. The court never made the successfulness in gaining control over the petitioner a factor in the first prong, and thus any force used by the officer would be a valid seizure under that prong.
It is important to note that in applying this test, the court made it clear that both prongs are not required. Simply, if there is no application of physical force, the only other way for a seizure to be present is if the petitioner was submissive to the officer's show of authority. The present case fulfills the first prong, as the use of a firearm is clearly an application of force, and thus the existence of a seizure in this case is supported by California v. Hodari D.
This court has set a precedent in many cases that a Fourth Amendment seizure occurs when an officer applies physical force with the intent of restraint, regardless of its success in halting an individual. In Broward v. Inyo County, the court held that the seizure occurs when governmental termination of a person's movement is effected through means intentionally applied, which is consistent with the language, history, and judicial construction of the Fourth Amendment. The violation in Broward occurred because Caldwell clearly intended to continue driving, and the police's actions, the barrier being instrumentally put into place, intended to forcibly stop his car. The intention of officers Madrid and Williamson in today's case was to stifle Torres' movement at all costs. The shooting conducted by the officers in this case is analogous to the barrier that was meant to halt the suspect in Broward. Looking at past precedent, it is clear that a seizure did occur under the definition held by this court. To further expand this point, this court should take into account the dangers precedents set by drawing an arbitrary line that bars Fourth Amendment claims against being viewed in its whole simply due to the fact the petitioner was able to escape initial contact with the police, due to the misapplication of the seizure definition. If this precedent were set, police officers would be permitted to apply any force, necessary or not, to a suspect as long as the suspect is able to flee.
As stated in Terry v. Ohio, the danger in the logic which proceeds upon distinctions between a stop, an arrest, or seizure of a person and between a frisk and search is twofold. It seeks to isolate from constitutional scrutiny the initial stages of contact between the policeman and the citizen. The case later states that by suggesting a rigid all or nothing model of justification and regulation under the amendment, it obscures the utility of limitations upon the scope as well as the initiation of police action as means of constitutional regulation. Simply put, constitutional regulation meant to protect people from any violations of the Fourth Amendment would not be applicable within the gray area presented under the respondent's definition of a seizure.
It should also be considered that this gray area of accountability is not one that would rarely be tested. Fleeing from the police is a common act, and under the respondent's definition of a seizure, any force, no matter the circumstance present, would not invoke a Fourth Amendment claim so long as the suspect is successful in fleeing the scene, which again is not a rare circumstance. It can be reasonably assumed that a suspect is more likely to flee a scene once the application of deadly force becomes present, therefore further expanding the respondent's proposed gap in the Fourth Amendment's protections. Furthermore, under the respondent's misguided definition of the Fourth Amendment, existing case law that has held that police officers may not use deadly force upon a fleeing suspect in all cases would be challenged again, so long as the suspect succeeds in fleeing the scene. Without the power of citizens to bring a constitutional claim, the prohibition would have no teeth. As stated in James Madison's Bill of Rights as proposed, the rights of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This further supports the idea in which the action used to stop a fleeing subject should not be deadly force unless it is necessary to prevent the escape of a fleeing felon, and the officer has probable cause to believe that the suspect poses a significant threat of violence to the officer or the community. Roxanne Torres was not an immediate threat to the community, nor did she appear to be armed at any point.
In the case of Tennessee v. Gardner, the petitioner was fleeing the scene of a suspected crime. The court held that apprehension by use of deadly force is a seizure subject to the Fourth Amendment's reasonableness requirement. To determine whether a seizure is reasonable, the extent of the intrusion on the suspect's rights under that amendment must be balanced against the governmental interest in effective law enforcement. This balancing process demonstrates that, notwithstanding probable cause to seize a suspect, an officer may not always do so by killing him. Although the petitioner was apprehended in this specific case, this court clearly had an intent to limit the cases in which deadly force would be authorized. This intention of the court would be completely negated had the suspect left the scene after the use of deadly force.
The Founding Fathers had a very clear intent to protect the people against unreasonable searches and seizures, as shown in the New York Ratifications Convention's debate and proceedings, where it was recorded that every free man has a right to be secure from all unreasonable searches and seizures of his persons, his papers, or his properties. And also looking at the Bill of Rights, which opens with the right of the people to be secure in their persons. The intent to protect, which was very deliberate by the Founding Fathers, would become ineffective if there is no recourse for cases where the police go beyond their permitted actions. This court has shown numerous times that the shooting of a fleeing unarmed suspect is unconstitutional, and the seizures can be defined as a laying on the hands or applications of physical force, whether done by an individual or inanimate object to restrain movement, even when it is ultimately unsuccessful.
In today's case, it can be confirmed that a seizure occurred under the definition provided by common law, which established by press precedent, beginning with Hodari, states that a seizure occurs when there is an attempt to detain an individual, regardless if it is successful or not. Ruling in favor of the respondents regarding the ways that they define a seizure would set a dangerous and contradicting precedence for courts and citizens. Secondly, the seizure in today's case is unconstitutional due to the officer seeking deadly force upon an unarmed suspect, which this court should find unreasonable in concurrence with Gardner. It is clear that the Fourth Amendment violations in regards to Roxanne Torres occurred under the unnecessary and unreasonable actions taken by officers in today's case. It is for these reasons that we pray the court rule in favor of the petitioner, Roxanne Torres, and reverse the decision of the lower court.